open for public.
Right.
I want you to ask him this question.
You just put it on YouTube and it's public. That's cool.
I think YouTube and Zoom are all owned by the same.
Okay. I'm Judge McBurney, and we are ready to go with the hearing on attorney's fees in case 2022 CV360083, which, if I remember correctly, was an appeal that A&A, I think, brought against Slutzky Realty. Mr. Cohen at one point represented A&A. He then withdrew, and the appeal that A&A brought was effectively abandoned, but that didn't mean that the defendant, for the purposes of the appeal, Slutzky Realty, didn't have to prepare and incur attorney's fees, et cetera. And so what we are working through is the question of attorney's fees for Slutzky Realty that were incurred in connection with preparing for an appellate proceeding that ended up not happening here at all. That's my understanding of what we're doing. Is there anyone on this call on behalf of A&A?
I'm here, Your Honor. John.
John, what's your last name, John?
Ahmadinho.
Okay, and what is your connection to A&A?
I own A&A.
All right, how do you spell your last name?
AHMADI, N as in Nancy, IA.
All right. And you at one point had Mr. Cohen as your attorney.
Yes, sir.
And you appealed a ruling from magistrate court that was not in your favor. Is that correct?
That's right.
Okay. And who is here on behalf of Slutzky Realty?
My name is Christopher Steele, and my co-counsel Nathan Johns are here on behalf of Slutzky Realty. So is Adam Slutzky. He's on the call as well.
All right. Great. I see all of you. Now, there was an attorney named Thomas Cox who was the one representing Slutzky Realty. Is he a colleague of yours, Mr. Steele, or you now represent Mr. Cox as well?
No, Thomas Cox was an associate of our firm. He worked under Mr. Nathan Johns, my co-counsel. Thomas Cox has moved on to an in-house counsel role and is no longer with the firm.
Okay, but same firm. Now we've just got different folks speaking on behalf of Slutzky Realty.
That's correct, Your Honor.
Okay. Well, why don't you tell me why you think under 91514 your client is entitled to having its fees, and it looks like the dollar figure is a little north of $5,000 reimbursed by A&A in this case.
Absolutely, Your Honor. So just to give it a little timeline, which I think lays out the argument here that we're making, that this proceeding was unnecessarily expanded, but also that several of the actions taken by the plaintiff in the appellant case were intended to delay or harass our client. We were granted an order by the magistrate court on January 28th, and on February 7th, the plaintiff filed for an appeal, okay? On February 22nd, when the Superior Court set the case for March 28th, plaintiff's counsel, rather, a day later filed to have kind of informally contacted the court to reschedule the case. And in that correspondence with the court on which we were copied, there were several comments made about wanting to go through the discovery process, wanting to have a jury trial over this issue. That's the first issue we have with this case. Despite the fact that the case got rescheduled because of a conflict, they also brought forth this idea that they wanted to have discovery and they wanted to have a jury trial. So we prepared appropriately. However, from the date of the appeal on February 7th all the way through April 26th, the jury trial, no request for discovery was ever made. No request was made to the court. No request was made to us. Opposing counsel never asked us for any documents. And so we feel as though this tactic was nothing more than just that, a tactic to harass our client, to delay payment of the judgment, and to delay these proceedings. Furthermore, We attempted to negotiate a settlement after the court rescheduled the case, and we got absolutely no response from the other side that was reasonable whatsoever. We were told that our client was not owed any money despite having a judgment from the magistrate court. We were told that essentially we'll see you at trial. Finally, and probably the most egregious in our opinion, is 2 months after winning the magistrate court's order, and almost 2 months after the case was set, plaintiff's counsel withdrew from the case with 2 weeks to go before trial. These records are in the court's hands, the withdrawal notice, and in the withdrawal notice, there is an email from plaintiff to his counsel where he is asking his counsel to withdraw. I think that was evidence of plaintiff's counsel as to substantiating their withdrawal from the case. So plaintiff asked his counsel to withdraw. 2 weeks later, showed up to a jury trial, not having secured replacement counsel, not having prepared in any way, shape, or form for a jury trial, not having prepared to reschedule the case or anything of the like. I think this is further evidence that all of this was just a tactic using the court's time to further delay and harass our client. And we think it's appropriate in this case, unlike many others, that attorney's fees under 1915-14 be awarded. Not that it's completely to the point, but we're in November of 2022, almost 10 months to the day, and we still do not have a resolution of the original judgment, which I think further goes to prove that plaintiff has no intention of paying this judgment, but rather just stalling and delaying, hoping that our client, who is with less means, will simply go away.
So how do I balance your perspective, and I understand your perspective, that the steps that you outlined were taken to delay and I don't know if harass is really the right word, but to avoid the inevitable of facing this judgment, with the litigative rights that any party enjoys to appeal a judgment from magistrate. I mean, certainly 9-15-14 was not meant to penalize someone who mounts an unsuccessful appeal. And I appreciate that's not what this became, because there really was no appeal in the end. It was abandoned at it really wasn't even the 11th hour. It was, we showed up for the trial and there was no lawyer for A&A, and A&A was unable to go forward. And so if I'm remembering correctly, I basically dismissed it for want of prosecution. But there's a difference between, you know what, I meant to do this. I was going to pursue the appeal, and then I realized after further evaluation, either it would be too expensive or it wasn't going to be particularly fruitful, and so I abandoned my appeal. I don't know that that's what 9-15-14 was set up to do, to prevent people from, in good faith, initially pursuing an appeal, realizing that wasn't going to go well, and abandoning that appeal. So distinguish this case from that scenario.
Absolutely, Your Honor. So I think some of the points Your Honor just stated prove the point that this was not a good faith attempt at an appeal. The actions of the plaintiff and the plaintiff's counsel speak to that. For example, the appeal was made on February 7th. The case was set for April 26th. In between, the plaintiff's counsel made it very clear to the court they expected to go through a jury trial. They expected to go through the discovery process. They never did. This is not just the plaintiff showed up 2 weeks before the trial without an attorney. They never started the process. They said to the court in the court's filing where they requested a jury trial and requested a continuance of this case, that they intended to go through the discovery process, and intended to have a jury trial. Not from day one did they make any request whatsoever to do any discovery, to carry this case forward in any way, shape, or form. Furthermore, even after counsel withdrew, which, by the way, for the record, was 2 months after filing for the appeal, counsel got a continuance, went through whatever process they went through. We have no idea what they went through. They never asked for any discovery or documents. They never asked us for anything. And then 2 weeks before trial, plaintiff asked his counsel to withdraw, which means he had notice that he had 2 weeks to prepare for trial, and he did nothing. He did nothing. He didn't ask for a continuance. He didn't seek a new attorney that we know of. He didn't come prepared in any way, shape, or form to argue this case. And so we think that the client's inaction over 2.5 months, and then of course the 2 weeks leading up to trial, and even today showing up without counsel, there is no intent or respect for the court here to follow the procedures and actually appeal this case. This is merely the other side going above and beyond to use the court to further delay paying this judgment.
So assume for a minute that I go along with your view that this wasn't a particularly good use of the court's time. Is that ever the measure that's to be applied with 91514? 91514 is meant to make you whole, not me. I don't get my money back for having my staff attorney get ready for trial, and we're working with jury services to get jurors ready. We of course have cases fall apart all the time on the eve of trial because they settle or a plaintiff dismisses. And sometimes there's not a settlement behind it. They just realize, dang, this isn't going to go. We're going to refile later on. And I don't think there is a mechanism for me sua sponte or for an aggrieved party on the court's behalf to say, this was a waste of the court's time, so you need to pay attorney's fees.
No, Your Honor, I point out that it was a waste of the court's time, more so to say that the plaintiff used the court to waste our client's time. We prepared, or Thomas Cox rather, prepared for a jury trial even after plaintiff's counsel withdrew at plaintiff's request. There was no filing for dismissal. There was no filing for delay. There was no filing for anything, no notification to us whatsoever that the jury trial was not going to proceed. So we came prepared on April 26th to actually argue to a jury this case. And so we're the ones, our client's the one that should be made whole here because they have spent a large amount of money, I mean, albeit small in the grand scheme of things, to our client a large amount of money to prepare for a trial that plaintiff wanted, plaintiff argued they should get, plaintiff delayed, plaintiff asked for time for discovery, never did any discovery, and then plaintiff showed up completely unprepared. They didn't, again, if they had dismissed the case, I might argue that that was a normal course of an appeal. They dismissed it. Or their counsel withdrew and then they filed something to continue it with the court in time to get new counsel. Or their counsel withdrew and they went out and showed proof that they tried to get new counsel. According to plaintiff, none of this has occurred. We have no record that they've done anything to actually pursue an appeal here other than file with the court and cause our client to spend time and money to prepare.
All right. Mr. Amandinian, do you want to, well, it's kind of tricky here. You can't represent A&A. We went through this before when everyone showed up in April. So you're here. I'm happy to hear from you. You just need to understand that what you're saying may help give me some context, but it's not anything that is being shared formally on behalf of the actual litigant here, which is the company you own. Does that make sense?
So, yes, it does make sense, but then I shouldn't say anything.
You don't have to say anything at all. I'm giving you an opportunity if you want to say, Judge, just so you know what was going on here. This is it. But no, you don't need to say anything at all. I just tend not to make people join these sessions and not be given a chance to be heard. I'll be able to keep separate the fact that whatever you say is in no way evidence, is in no way a representation on behalf of A&A. But it's also fine if you want to say, hey, I didn't want to miss this. I didn't want you to think that I wasn't interested, but I don't have anything to add.
Yeah, that's certainly true. I didn't want to make you think that I didn't want to attend the scheduled time of the court, but I really don't have anything to say.
Okay. Well, I appreciate that. Mr. Steele, I'm looking at some of the submissions. So Mr. Cox provided an affidavit from April 29th, which would have been the couple days after the case went away because there was no trial and it was dismissed for want of prosecution. And he indicated that from the day of the entry of the magistrate order, so January 28th of this year, through the date of his affidavit, April 29th of this year, he and the firm had incurred fees and whatnot of $5,313. Is that number you're relying on?
Yes, Your Honor. We pulled the invoices in preparation for today and came up with a slightly lower number, but I'm happy to submit. And we sent those as an exhibit. I think it came up to $5,298.68. I'm not sure why there's a discrepancy there, but approximately $5,300 is the amount in question.
Okay. Well, and I appreciate your thoroughness, and it ought to be the number you're willing to stand behind. It sounds like it's about a $15 difference, but every dollar matters. And I do have your submissions. I was just looking at the affidavit.
Yes, sir.
All right. Anything else you want to add from the 9/15/14 perspective?
No, Your Honor. I think we've said it. I think this is an extreme case, and I think that the actions of the plaintiff warrant the attorney's fees. So I think that's all there is to say.
Did you find any cases that are of this tenor where the fee award is not so much it was a frivolous position? Because I see that sometimes where one side advances a fraud claim, but everyone points out from day one, there was no misrepresentation. And yet the person persists with the fraud claim. And then at the very end, like, yeah, you know what? There was no misrepresentation. So we dismiss. Well, wait, you got a 10-page letter from opposing counsel before you filed your complaint documenting how there was no misrepresentation. So there's no good fraud claim. That's the frivolous or baseless claim. In some ways, we don't have that here because I don't know what you'd be able to point to about being frivolous. There was an appeal. It may not have been a real strong appeal. It just wasn't ultimately prosecuted. It was brought, and then your perspective is it was used to drain your client of resources, maybe in the hope that he would go away, but it was not meaningfully prosecuted. And so I guess that would be unnecessarily expanding, but it's a long way of asking, have you found any cases that support the award of fees under 9/15/14 because of something like this? We'll call it more gamesmanship than pursuing a baseless claim.
I don't have any prepared for the court. I'm happy to submit them in a supplemental brief, but there are plenty of cases, if I recall correctly, where plaintiffs have gone forward in bad faith, and I think that's what we have here. It's not just that, of course, the plaintiff has the right to appeal. We're not denying that. In fact, we were ready to go forward with appeal. Mm-hmm. But the actions, or rather the inaction of the plaintiff point to the fact that this was not a good faith attempt to appeal. It was bad faith moving forward, and they took 0 steps to actually go through this process, even up to the day of showing up without counsel. And so we think because they acted in bad faith, and I'm happy to submit those cases, that warrants the conclusion that we're falling under, which is that they intended to do nothing more than delay or harass our client.
Okay. Well, it would help me if you do that. You do not need to prepare a brief. I want to minimize the additional work that your firm needs to do on behalf of Slutzky Realty. It would be as simple as you sending an email to Ms. Niles, listing 3 or 4, 2 or 3, just needs to be a handful of cases that point me in the direction of a body of case law that goes into the bad faith angle rather than this was a baseless or a frivolous claim.
Absolutely, Your Honor. I'd be happy to send those over to you.
Okay. I realize we're on the day before Thanksgiving, so I'll let you set the timeline. Just know that I won't be in a position to move forward with ruling on your motion until we get that case law supplement from you.
Of course. I think no later than close of business on Monday, you'll have that, or I should say Ms. Miles will have that probably today, but certainly no later than Monday close of business.
Fantastic. And again, you don't need to do much exposition. Just like, hey, if you look at these three cases, they're going to support either directly or at least through analogy, Slutzky Realty's perspective.
Absolutely, Your Honor. Thank you.
All right. Well, I appreciate everyone dialing in on this day before break. I will take this under advisement. I won't take any action until that email makes it to Ms. Niles, and then I will figure out what we're going to do. Thank you, everyone.